Welcome to the Ohio Department of Transportation. We're going to be talking about Tenant Owned Improvements module. This is the Department of Transportation online course for Acquisition 103 for Tenant Owned Improvement. This course will cover the basic principles of tenant owned improvements of a parcel on how to use the appropriate forms when handling these acquisitions. Also, this course will cover a mini case study for tenant-owned improvements. At the end of this module, be given a knowledge check to make sure that you understand the process of tenant-owned improvements. Looking at the agenda, we're going to be looking at a small introduction, the laws that implemented into the procedures, acquisition processes, the RE 95. We're going to be looking at other forms that go along with the tenant-owned improvements. What is salvage value? And we're going to be looking at the brochure for the tenant-owned improvement and then the mini case study. This is coming out of our real estate manual section of the 5302. The improvement to real property that are acquired for a highway project that are owned by a tenant. Common examples include signage, outdoor advertising, fencing, and the responsibility of this is the district's. The district office must determine if the improvement in the area to be acquired is real property. If so, also determine if the improvement is owned by the fee or the tenant owner. Now, we have a host of laws and regulations that have to be implemented into these procedures. And as you see that they're all listed, USC 42, Chapter 61, Section 4652, 49 CFR 24.105, ORC, which is Ohio Revised Code 163.60, OAC, Ohio Administrative Code 5501, 2-506. All of this is implemented into the real estate manual in the 5302 section of the tenant-owned improvements that are real property. This acquisition procedure applies to the improvements that is in the take, the improvement that is real property, the improvement that is owned by a tenant, the fee owner, and the tenant must agree to ownership. If an offer is made to the tenant for the improvement cannot be considered as a relocation item. The amount offered to the fee owner is reduced. Here's a host of the laws around and reinforces the tenant-owned improvements out of the 49 CFR 24.105, acquisition of tenant-owned improvements. And we identify that this shall include any improvement of the tenant. So we kind of highlighted some of the areas that are very, very important. And item B, the improvements considered to be real property, any building structure or other improvement which would be considered to be real property if the owner of the real property on which is located shall be considered to be real property or purpose as this subpart, which we get into the appraisal of the establishment of the just compensation for a tenant-owned improvement. Just compensation for a tenant-owned improvement is the amount which the improvement contributes to the fair market value of the whole property or its salvage value, whichever is greater. That is very important when we get down a little farther into the process. We identify that under special conditions for a tenant, no payment shall be made to the tenant for any real property unless these conditions are met that you see here. The tenant owner is considered for payment, assigned transfers, and releases to the agency all the tenant-owned rights, titles, and interests in the improvement. The owner of the real property on which the improvement is located disclaims all interests in the improvement. That's what is known as the RE 56, the disclaimer form. The payment does not result in a duplication of any compensation otherwise authorized by law. So those are the items that we need to keep in mind when we're looking at compensating tenant owners. Implementing these laws into procedures. Step one, we broke these into various steps so that way you'll be able to identify it a little easier. Determine if the improvement in the take is real property and determine if the improvement is owned by a tenant. To do that, you need to use the form called the RE95 and do the RE95 process. You'll find this procedure that's located in the Real Estate Manual section 5202.01. Step 1, Item B, the fee owner must disclaim any interest they have in the tenant-owned improvement. So you cannot have the tenant owning it and then the fee owner owning it. In this case, there'll be a form known as the RE56 that would need to be signed by the fee owner disclaiming ownership of that improvement. Here is the RE95 form. There's 2 pages to this particular form. Here is the RE56, the disclaimer form that the owner would need to sign, disclaiming ownership of that particular improvement. It is important that everyone signs the RE95 form. If there isn't documented agreement regarding the clarification and ownership of the improvement that is taken, there will be a dispute between the fee owner and the tenant owner regarding who owns the improvement that is a part of the take, and the property may be appropriated, requiring a jury to determine compensation and a judge determining who receives the compensation. The next item is step 2. The contributory value of the tenant-owned improvement is to be determined. So for that to happen, the evaluation ignores the tenant's interests and it's assumed the improvement is owned by the fee owner. The improvement is valued based on its contributory value to the whole property, and the appraiser or the reviewer must be scoped to do this properly. So they need to be aware ahead of time if there's a tenant-owned improvement that is out there for them to evaluate it. It has to be ignored for the tenant interest, and then eventually it'll be valued for the contributory value. The contributory value of the tenant-owned improvement is shown on the line of item RE22. This is the RE22 form that is used. Here is the apportionment form, the RE22-1. The RE22 basically shows the contributory value for the whole, including all of the aggregate ownership plus the total compensation. And then the RE22-1 is the apportionment sheet for identifies the total of all the compensation. Then it breaks itself out with the fee owner receiving X compensation and then the bill of sale receiving X compensation, which is known as a BS. Looking at the salvage value for the tenant owner of the improvement, which is known as the RE68 form. So this RE68 form has 2 pages to it, which is identifying the salvage value. And this is important to be able to determine if the contributory value is more than the salvage value. This is the form that basically allows you to determine the cost of the salvage value. What is salvage value? Well, this is out of 49 CFR 24.2. The probable sale price of an item offered for sale to a knowledgeable buyers with the requirement that it be removed from the property at the buyer's expense. Please note that relocation is not eligible for this. This includes items for reused as well as the items with components that can be reused or recycled when there is no reasonable prospect for sale except on this basis. The next step, on step 4, now an offer is going to be made to the fee owner because now we have seen the determination of what the fee owner is going to receive and what the tenant owner is going to receive. The amount that is offered is the FMVE minus the contributory value of the improvement. The improvement is owned by the tenant owner, so the fee owner will not see that compensation. They're going to use the Notice of Intent to Acquire in Good Faith offer, which is known as the NIAGFO. And please note that the amount has been reduced Once again, the amount has been reduced in its value for the tenant-owned improvement. Then we're going to make an offer compensation to the tenant owner, which basically of the improvement that's classified as real property that is taken. First, you must determine which offer is the greater of. We went over this out of 49 CFR 24.105C, contributory value or salvage value. So the greater of the offer is going to be on the NIAGFO. This is a separate negotiation with its own parcel file. And this parcel file is going to be known as the bill of sale, commonly known as a BS parcel, but it will be known as the bill of sale. Step 5, the tenant owner must convey all rights, title, and interest he has in the tenant-owned improvement to ODOT. To do that, the tenant needs to sign what is known as the Form RE66CC Bill of Sale from tenant. Here is the Bill of Sale of tenant form. Basically, it'll identify the county route section, and then it will identify the date that is executed, the parcel number, the description that is listed for that's being acquired for the tenant-owned improvement, and then identifying the signature of the person with regards to them accepting that the cost that we have made that determination. Or if there's an administrative settlement, it has to be the same exact way. Step 6, the fee owner signs ODOT instrument. This conveys the property right to ODOT. Step 7, there must be assurances there are no duplication of payment. So we look at this as the district must recognize the tenant's interests early in the acquisition so that the tenant's share of compensation is not overlooked, resulting in all the FMVE being paid to the fee owner. What is the duplicate of payment? Well, we have a couple of examples. We have payment to a tenant owner for an improvement in the acquisition process and then providing the same improvement with relocation benefits. Paying fee owner 100% of the FMVE and paying the tenant for the improvement. Those are those examples. What happens when the agreement is reached with the fee owner but not the tenant owner? Depending on all of the facts surrounding the acquisition and the Assistant Attorney General's handling the case, either the entire parcel is appropriated or at a minimum, the tenant owner is appropriated. It relies upon the Attorney Generals to make that decision. But generally, the entire parcel will go into appropriation, and then the Attorney Generals will make the decision if they need to make the separation or not. What happens when the RA95 is not signed or there is a discrepancy between the owners about who actually owns the improvement to be acquired? Full FMVE is offered to the aggregate ownership. The aggregate ownership is the fee owner and the tenant owner. One NIAGFO listed the aggregate ownership, so that means one NIAGFO would have the fee owner's name and the tenant owner's name on it. These people must decide how compensation will be allocated between them. If an agreement cannot be reached, the entire property is appropriated. Here is the brochure developed to assist acquisition professionals. This is for the tenant-owned improvement as well as the owner retention. You will see this brochure again when we get to the owner retention. So in this case here, we did develop a small brochure for the purposes of a tenant-owned improvement classification of real property, giving you the law citations, giving you a brief step procedure of the process that you have to go through for tenant-owned improvement, as well as the evaluation process along with that, and then closing and securing the property rights. The acquisition form to be used when dealing with the tenant-owned improvement is found on our ODOT real estate webpage. We have the RE95 classification form that we've showed you previously. We also have the RE56, the disclaimer form, the RE68, the salvage value estimate form, and the RE69 bill of sale for tenant. These forms, as you see, are located on our website that we've identified. Now we're going to look at a mini case study for tenant-owned improvement. So here's this mini case study. We have a sample project out of Warren 71, 10.00, parcel 20. The owner is Bailey Smith. The tenant owner is James Hoffman that operates a custom body shop. There is no mortgages or other liens on the property, and the taxes are current. Here's the scenario. ODOT is acquiring a strip that is 20 feet deep by 218 feet long, containing 0.10 acres. There is a sign located on the proposed right-of-way, which is owned by the tenant. The sign is an on-premise sign with a double-sided wood face. The sign is 8 feet wide by 10 feet long and is supported by 3 4-inch 4x4 wooden posts. You are the negotiator assigned to prepare the documents in the acquisition folder and to negotiate this parcel to completion. As the negotiator, you contact an independent sign company for the salvage value of this sign. Due to the age and the condition of the sign, the salvage value is $360. The estimate is based on a 30% contributory value. Here is an aerial picture of the building and where we see the acquisition of the WD that's being acquired, that's highlighted in the blue dashed line. We also see where the sign is located in that area that's highlighted in green. What form is used to identify what the improvement is, personal or real property? And when should this form be used? The answer to that would be it's going to be an RE95, should be completed early in the acquisition process prior to the appraisal process. The district must determine if the improvement in the area to be acquired is real property, and if so, also determine if the improvement is owned by the fee owner or the tenant. To make these determinations, the district shall use the RE95 and comply with the procedures for the RE95. And of course, we have our manual section that it references out of 5302.01. What form is used to disclaim the fee owner's interest in that particular sign? So if you remember, as we were going through the beginning parts of this course, we said it would be the RE56 disclaimer form. It references the manual out of 5302.01. The negotiator shall ensure the fee owner signs the RE56 disclaimer form. By signing this form, the fee owner is disclaiming any interest in the tenant-owned improvement. Name 2 reasons why the form should be signed by the fee owner. Let's take a look at that. We need to make sure to comply with the regulations requiring the fee owner to disclaim any ownership in the tenant-owned improvement and to avoid any conflict between the tenant and fee owner regarding who claims ownership of the property which require an appropriation. What form is used to show the aggregate ownership of compensation, including the contributory value of the sign? That answer is going to be the RE22, the review appraiser's fair market value estimate. And this is where you remember the blue sheet, it separates out the fee ownership as well as the fee compensation and the bill of sale. So that's your RE22-1, the apportionment of the right-of-way cost. Here is the Bailey form that shows parcel as being acquired. And as you would see, we now show the total dollar amount. And here we have what is known as the blue sheet, the RE22-1, where it separates the dollar amount for what the bill of sale would receive as well as the fee owner would receive. Utilizing the RE22-1 and the salvage value determination on the previous page, please see the owner and the tenants will be offered. So What is the amount of compensation that will be offered to the fee owner? Well, in this case, that's going to be $3,600. And then my next question is, what is the amount of compensation that will be offered to the tenant owner? And that is $1,200. If you remember, the salvage value was conducted and it was $360. So the greater of salvage value or the contributory value would be the contributory value. So the compensation to the tenant owner would be the $1,200. And then here is a brief explanation of what we just mentioned right here. This represents the contributory value award to the tenant owner. We have a federal citation, just compensation for the tenant owner improvement contributes to the fair market value as a whole and or its salvage value, whichever is greater. What form is used to determine the salvage value of the improvement? And that is the RE68 salvage value form. This was the document that's used to make your determination of the salvage value cost of that improvement. Why must this form be used to determine the salvage value? And that is to implement the regulations requiring the tenant owner receive the greater of the salvage value or contributory value. Once again, the district must scope the appraiser to estimate the contributory value of the tenant-owned improvement, assuming the improvement is owned by the fee owner. What form is used to convey the tenant-owned improvement interest to ODOT? And that is the RE69CC, the bill of sale for the tenant-owned improvement. What form is used to present the compensation to both owners of this parcel? And that is the notice of intent to acquire and good faith offer. Be two separate offers that would be made, one to the fee owner and one to the tenant owner of the improvement. The form on the next page is the salvage value, RE68. Let's review the form of this parcel. So here we have the RE68 form that is present, which is on the Warren 71 10.00. The parcel is 20BS, and of course we have the PIN. So we go to the name of the person that owns the improvement, and that's Mr. James Hoffman. We put a description of what the person owns on that particular property, which is the description of that sign. And the next one is identifying the location of where that sign is actually at. The next one is it analyzes the improvement if it's nominal. So if the improvement cost is $10,000 or less, it's considered as nominal. If the improvement is more than $10,000, then it is considered as a not nominal. In this case, it is considered a nominal cost, and then you just identify that what you actually did, you made a phone call, and the salvage value was determined by the company that represented that sign and was able to give you a cost of salvage value of that sign. And so we came up with $360. On the next page of this, then you would move right straight down of putting in the brief description and then the cost for the sign, and then the document would be executed. The NIAGFO for the fee owner. Here is the notice of intent to acquire good faith offer. And once again, these are the legal protected rights that the fee owner would see as he is presented that offer. And that continues to the next page. We're now at the good faith offer for $3,600. The area that is bolded beneath it, it talks about for this acquisition, there is a tenant, the improvement which the sign is owned by James Hoffman. Good faith offer does not include compensation for this sign. So it clearly states that the fee owner would not be compensated for that improvement that is owned by the tenant owner. Now we're going to look at the NIAGFO for the tenant owner. James Hoffman for the Warren 71 10.00, parcel 20BS. We've identified the parcel. We are also identifying the description as well that's being acquired. And we go to page 2, which basically provides him the same summary of his legal rights, just like the fee owner. And then once again, it continues on to the next page. And then finally over to the good faith offer, where he is offered $1,200, which is the contributory value of the sign. And notice that we do say in this contributory value that the good faith offer is only for the double wide wooden sign, 8 feet, approximately 8 feet wide by 10 feet long, which is the tenant owned improvement located within parcel 20 WD. So then that clearly states that we're only offering the contributory value of the FMVE for the improvement, for the tenant owned improvement. Next form is the bill of sale, the RE69CC, and is dated that the owner had accepted, which was January the 15th, 2015. And this is the actual bill of sale that is used, giving the date of Mr. Hoffman signing it, being that it's parcel, giving a description of what is being acquired for the improvement that you actually see. So the sign is a double sign wooden face sign at 8 feet wide, 10 feet long, and supported by 4-inch by 4-inch posts. Identifying also the dollar amount, which is $1,200, and then of course giving another description in item 4 of the fixture that is going to be impacted by the project. The signature of Mr. Hoffman that is required. Now it's time for a knowledge check.